Hello, everyone. My name is Jessica Nelson, and I'm an associate historian for the Joseph Smith Papers of the Church History Department, and it is my pleasure to welcome you to this afternoon's session of the Church History Symposium. The theme of our session today is Voting Rights Denied, Polygamy, and the Idaho Test Oath. At the start of this session, I will introduce our speakers in the order in which they will present their papers. John Estinger is a graduate of the S.J. Quinney College of Law, University of Utah in Salt Lake City, where he was an editor of the Utah Law Review. In addition to a Juris Doctorate, he holds degrees in political science and history from the University of Utah. He has published in the Journal of Mormon History, John Whitmer Historical Association Journal, Idaho Law Review, and Utah Law Review. He is presently a deputy prosecuting attorney for Ada County in Boise, Idaho.
So any attorney will tell you that in trial, you start with a really good witness, you bury your so-so people in the middle, and then you finish off with a superstar. And so I feel right where I should be, in the middle. In an Idaho State Conference in May of 1885, Heber J. Grant told the assembled crowd, "The Constitution guarantees us freedom of faith and religious action as long as it does not interfere with the rights of others." This statement was made a few months after Idaho disfranchised all Latter-day Saints. The passage of this law in 1884, known as the Idaho Test Oath, prohibited saints from voting, serving on a jury, and holding public office. However, the Idaho Territory was not the only jurisdiction to attempt to disfranchise their citizens through a test oath. A Utah oath was passed in 1882 through the Edmunds Act, and an 1887 oath was passed through the Edmund-Tucker Act. The state of Nevada also passed an oath resembling Idaho's in 1887. While many saints were avoided prosecution by hiding, they were also told by George Q. Cannon to make a fight in the courts. And so these legal fights over these oaths took place in federal, state, and territorial courts, where the saints had varying levels of success. Through their efforts, the Nevada law was ruled unconstitutional in 1888. The saints were able also to mitigate the harshness of the federal law. However, they were unable to do anything in Idaho. The saints attacked the law through many lawsuits, but it was continually upheld as constitutional by the courts. In the Idaho case, Davis v. Beeson, which was eventually appealed to the U.S. Supreme Court, the test oath was once again upheld. And this caused the church considerable worry, as the saints could then be disfranchised in all territories, including Utah. When President Wilford Woodruff abandoned plural marriage, one reason he gave was that the anti-polygamy laws, quote, have been pronounced constitutional by the courts of last resort. And this was done in part because of the holding in Davis. In 1882, Congress passed the Edmunds Act, which created the new law of unlawful cohabitation. It prohibited jury service of certain individuals and disfranchised polygamists. Regarding voting, the act stated that no polygamist, bigamist, or person cohabitating with more than one woman would be permitted to vote. This did not prohibit those believing in the doctrine of polygamy, just actual polygamists. And it should also be noted that this law did not specifically impose a test oath. It simply prohibited the right to vote of certain individuals. Prior to the Edmunds Act, the right to establish voting guidelines was granted to the Utah Territorial Legislature through their Organic Act. So since September 1850, it was the legislature who would prescribe those voting qualifications in Utah. However, in that same Organic Act, the supremacy of federal law was also declared. Quote, that the Constitution and laws of the United States are hereby extended over and declared to be in force in the territory of Utah. So thus, federal law prevailed. The Edmunds Act also created the Utah Commission, a board of 5 individuals whose job it was to enforce voting requirements. They got right to work, and they passed a test oath requiring all voters to take an oath where one had to swear in part, "I am not a bigamist nor a polygamist." So this oath did not sit well with the people of with Utah, and many challenged the law in court, including the voting provisions. So the Utah saints, polygamist and non, registered to vote, and these attempted registrations led to many lawsuits, which eventually went up to the Supreme Court in a case called Murphy v. Ramsey. So on March 23, 1885, Justice Matthews delivered the decision in Murphy v. Ramsey. George Q. Cannon was actually present at the Supreme Court and described it as partly favorable, though the general tenor was unfavorable. And his description was spot on. It was something of a mixed bag. It upheld the Edmunds Act as a whole, but found that the test oath was unauthorized. In explaining the overreaching nature of the oath, the Supreme Court declared that the commission was not authorized to prescribe any qualifications for voters as a condition of registration, and that it was without force and of no effect. So had the decision stopped there, it would have been considered a great win for the Saints, but sadly it didn't. After declaring the oath itself unauthorized, the court found that the act was constitutional, specifically the section that held that no polygamist shall be entitled to vote. So in discussing Congress's authority to pass such laws, the court declared, "The people of the United States, as sovereign owners of the national territories, have supreme power over them and their inhabitants." So it's these reasons why territories, especially Utah, wanted statehood as soon as possible. The court continued, stating that it was Congress who decides who shall participate in the election of its officers in the territories. And they also reminded the Saints that they may therefore take from them any right of suffrage it may have previously conferred. So Congress listened to the Murphy decision because in 1887, when they passed the Edmunds-Tucker Act, they included a test oath for polygamists requiring anyone who planned to vote, serve on a jury, or hold office to swear to it. They also, in just an absolute fit of meanness, disfranchised all women. But the oath passed by Congress required the individual to swear several things, including that they would obey the Act of 1882, as well as they will not, directly or indirectly, aid or abet, counsel or advise any person to commit any said crimes, referring back to polygamy. Now, this oath, the 1887, was never challenged in court per se, but in Anderson v. Tyree, a women's suffrage case in 1895 before the Utah Territorial Supreme Court, they did hold that, quote, "The oath of the Edmunds-Tucker law applies to all territorial elections." So while the federal test oath and voting prohibitions were difficult for Utahns, male and only male, Utahns were still largely able to work around them. 90% of Latter-day Saint men were still able to take the oath and vote. Thus, the use of federal law in disfranchising the Saints was not particularly effective. So in 1886, Washington wanted to annex northern Idaho into its territory, and Nevada wanted to annex southern Idaho into its state. So Nevada, believing that this would happen, felt the need to pass a test oath similar to Idaho's so that when they stole southern Idaho, those Saints would continue to be excluded from politics as soon as they were in Nevada. So at first it was proposed to do this by constitutional amendment, which was the right answer, but they believed that that process would take too long. So in March of 1887, the Nevada legislature passed a law disfranchising all Latter-day Saints and passed a test oath. And this oath stated in part, "I am not a bigamist or a polygamist, that I neither teach nor practice bigamy or polygamy, that I am neither a member of nor belong to the Church of Jesus Christ of Latter-day Saints, commonly called the Mormon Church." So as you'll notice, this oath did not only focus on the crime of polygamy, but also prohibited membership in the church. Nevada's oath was the only one that said the name of the church by name. So on March 3rd, 1887, the bill became a law. So the annexation bill, splitting up Idaho, passed Congress on the same day, March 3rd, 1887. All that was left to do was President Grover Cleveland needed to sign it. Idaho lobbied hard, and the president did not sign the bill, electing the pocket veto, saving Idaho territory. So while annexation was dead, the test oath was still law, but it was never really enforced. Even though it was never enforced, Latter-day Saint George B. Whitney arranged a test case where he tried to register to vote. He told the registrar that he was qualified to vote under the Nevada Constitution, but he could not take the 1887 oath as he was a member of the church. But then he made clear to them that, quote, this was the only reason why he refused to take the said oath, or in other words, I'm not a polygamist. So on October 8, 1888, the Nevada Supreme Court found the test oath law unconstitutional and inconsistent with the Nevada Constitution in State v. Finley. The decision looked at the right of suffrage granted by constitutions and held that it is not in the power of the legislature to deny, abridge, extend, or change the qualifications of a voter as prescribed by the Constitution of a state. So in very harsh language, the court noted that if the legislature could simply pass a law disfranchising Latter-day Saints, quote, it could by like methods exclude from the elective franchise all persons belonging to any other church or members of any political party, social organization, or benevolent order. They went on to talk about how in effect it would make the Constitution worthless as voting rights, quote, would be placed entirely at the mercy, will, and caprice of the legislature. So because Nevada was a state and there were constitutional guarantees of suffrage, disfranchisement didn't work. Though test oaths would be ineffective in states unless done by a constitutional amendment. So on to Idaho. Unlike Utah, the Saints in Idaho had to fight for the right of suffrage on two fronts. First, they had to fight laws passed by Congress that applied in the territories, such as the Edmunds Act, but they also had to contend against local laws passed by the Idaho Territorial Legislature. It was these local laws that ultimately led to the U.S. Supreme Court decision in Davis. Idaho, like other territories, were given the right to determine voting qualifications through its Organic Act. When a new territory is formed, Congress would pass an Organic Act that would sort of function as a constitution of sorts until the territory could earn statehood. And Idaho's act stated that after the first election, the legislature would then decide those qualifications. So the Organic Act also set up a system that led to severe distrust of the federal government. The act stated that the governor, secretary of the territory, the judges, the U.S. District Attorney, and the marshal would all be appointed by the president. So because they were political appointees and not elected, they were not accountable to Idahoans. The only positions that could be held by actual Idahoans were the territory legislative seats, but under that same Organic Act, legislative acts could be vetoed by Congress, theoretically voiding home rule, and they were. So other problems faced by the appointments were the fact that many of the federal appointees were inefficient or just plain corrupt. One secretary of the territory fled the territory with the legislator's entire financial budget. A governor also quickly left the state, taking with him over $45,000 allocated for Native Americans. Another governor was removed when evidence was shown of his absences, his theft of public funds, and the selling of pardons. And so Idahoans just really disliked these carpetbaggers, as most were also appointed by Republican presidents, whereas Idaho is generally a Democratic state during its territorial period. And so this led to a severe distrust of the federal government, which is still felt in Idaho today. Both political parties in the territory also largely agreed they wanted home rule for Idaho. Further, non-Mormon Idahoans also felt they would never become a state with the Mormon problem unresolved. And so the non-Mormon citizens of Idaho felt the federal government was not doing enough with the Mormon problem. So when the Edmunds Act was passed, Idahoans were not impressed. While this act was unpopular with the Saints, just like Utah, it became clear that they could work within the system, as there were many Saints but few polygamists. And seeing the ineffective nature of the Edmunds Act, non-Mormon legislatures in Idaho attempted to strengthen these laws for years. So the Idaho test oath was finally passed by the territorial legislature in 1884, disfranchising all Latter-day Saints in the territory, prohibiting them from jury service and from voting, as well as holding public office. And this law was only passed after two Mormon legislators lost their seats in a disputed election in which forged telegraphs were sent, purportedly from President John Taylor, and forged ballots were used. So with the Saints losing these seats, An oath was passed that disfranchised not only actual polygamists, but any, quote, member of any order, organization, or association which teaches, advises, counsels, or encourages its members, devotees, or any other person to commit the crime of bigamy or polygamy. So after this test oath, George Q. Cannon told the Idahoans to fight. He told them, "It was cheaper and better for us to make a fight in the courts than to have the same treatment meted out to us that we formerly experienced, namely, having mobs drive us from our homes." So the first major case challenging just the voting aspect of the test oath appeared before the Idaho Supreme Court in Enos v. Bolton. And this case dealt with a Latter-day Saint in Bear Lake who attempted to take the oath. The case was argued before the Idaho Supreme Court in February of 1888. Ultimately, the court held that the right of suffrage is not a natural right, nor an unqualified personal right. Rather, they said, it is something that can be granted and taken away by the government. Thus, they found the act constitutional. The next major attempt at invalidating the law was Woolley v. Watkins in September of 1888. Woolley sought to register in Bear Lake County. He offered to take and subscribe to the oath. He felt that he could sincerely do this, as the church in Idaho had been silent or quit teaching polygamy since 1886. They just didn't teach it. And so at the district court level, he was ruled against. The judge found that the doctrine of polygamy had not actually been discarded. Quote, "These doctrines and teachings have not been repealed, and that membership in such organization is inconsistent with the right of such member to vote under this law." Eventually, the Idaho Territorial Supreme Court heard the appeal on whether the test oath violated the free exercise clause of the First Amendment and whether it violated due process. The court cited United States v. Reynolds for the doctrine that the government cannot interfere with mere religious belief and opinion, but they may with practices. They found that the support, teaching, advocating was more than a belief. Regarding the due process claim, the court rejected it, holding, "The right of suffrage may be granted, abridged, or taken away by the government in its discretion." The third major attempt resulted in Davis v. Beeson, a case that reached the U.S. Supreme Court. In April of 1889, Samuel Davis was indicted along with 55 other individuals for a conspiracy to unlawfully pervert and obstruct the due administration of the laws of the territory. Specifically, he withdrew from the LDS Church, voted, and then rejoined at a later time. So in September 1889, Davis's trial was held where he was convicted. And his actions after the trial show that this was an intentionally created situation where he would be arrested so he could apply for a writ of habeas corpus, which when denied would create an additional appealable issue. So church lawyers made arguments regarding religious liberty, mainly arguing that membership in the Mormon Church should not lead to being disfranchised. As you heard a minute ago, they argued the free exercise of religion, the application of the 14th Amendment, Article 6 of the Constitution, and they also tried to argue that Congress has already legislated on this issue, so Idaho can't. Idaho Saints didn't have to wait long for the court's decision, as it was delivered by Justice Field on February 3rd, 1890. And the opinion cannot be viewed as anything other than a blistering rebuke of Mormonism. Field discussed Reynolds and distinguished it from Davis. Fields reiterated the holding of Reynolds, saying that laws are made for the government of actions, and while they cannot interfere with mere religious belief and opinion, they may with practices. He then gave an example of impermissible religious belief and opinion, human sacrifice, and asked if one would seriously consider that the government could not interfere to prevent a sacrifice. He asked, can a man excuse his practices to the contrary because of his religious belief? In answering himself, Justice Field said to permit this would make the professed doctrines of religious belief superior to the law of the land, and in effect, to permit every citizen to become a law unto himself. Crime is not the less odious because sanctioned by what any particular sect may designate as a religion. The opinion then turned to the Idaho test oath and the ability of the territorial legislature to prescribe voting qualifications. They looked at the Idaho Organic Act and found that really the only limitations it placed on the Idaho legislature is that a voter had to be 21 years of age and that they could not deny voting based on race, color, or previous condition of servitude. Beyond that, Idaho does have the power to, quote, prescribe any reasonable qualification of voters, including the Idaho test oath. So the Idaho test oath was upheld and ruled constitutional. There was nothing that would prevent the other territories or Congress from passing a similar law. And so the fact that the Idaho test oath could be passed in all the territories was not lost on anyone. The Utah Commission planned to impose an Idaho test oath on Utah. Congress looked at imposing an Idaho test oath on the territories. Years later, attorney Franklin S. Richards recalled that after Davis was decided, quote, Senator Cullum and Congressman Strubble presented bills in Congress providing that no person being a member of any religious organization that sanctions the practice of polygamy should vote, serve as a juror, or hold office in Utah. Candidly, Richards went on to admit that Davis was one of the major reasons for the manifesto. He continued, quote, the imminent danger of these bills passing Congress was the immediate cause of the issuance of the manifesto. I was in the president's office on the morning of September 25th, 1890, when President Wilford Woodruff came in and stated that the Lord has made manifest to him, after much prayer and supplication, that our people must submit to the law, inasmuch as they had exhausted every legal means of showing its unconstitutionality. And so in conclusion, I'll argue, it was not the federal government or the Utah Commission's work that led to this. Rather, it was the citizens of the Idaho Territory, distrustful of the federal government and wanting statehood and home rule, who worked through the systems of territorial law to accomplish their purpose. Thank you.
All right, so we have about 10 minutes for questions. These mics here in the aisle should be on, so you should be able to come here and state your question. Thank you.
Okay, this might be a silly question, but has the Idaho test oath been repealed?
Yes.
So what are the circumstances of that?
So I'm glad you asked that. It's pretty interesting. So after the manifesto, Latter-day Saints in Idaho thought, okay, we can vote, but the Democrats blocked them again, passing even more strict laws. Basically a law in 1892 kind of saying if you've ever been a Mormon, you don't get to vote. However, shortly after that, Republicans started making inroads with the Mormons, who were mostly Democrats. They decided, hey, they didn't have our back, let's link up with the Republicans. And so the Republicans started helping them get their vote back. So legislation was passed, so by 1896, they were able to vote. However, the test oath was put into the Idaho Constitution, and it was not removed until 1982. And to show how we are viewed even in 1982, only 2/3 of the voters voted to remove it. So there was still a third of Idaho who wanted it left in.